Abhishek, show the banner.
Abhishek, you can begin. Your mic is on now.
Okay. ये सबको म्यूट करना पड़ेगा उधर बाकी
कर दिया आप चालू करो प्लीज.
Okay, I have to stop this banner sharing then.
Yeah, now you can begin.
Hello everyone. Hello everyone. I welcome you all on behalf of Supreme Court Young Lawyers Forum. Hello everyone. I welcome you all on behalf of Supreme Court Young Lawyers Forum. Today we gathered here for our second webinar on the topic COVID-19, resumption of regular courts, challenges ahead and remedial measures. As the voice of young lawyers can be heard by the Honorable Chief Justice of India and Honorable Chief Justices of different high courts. In our first webinar on this topic, our guests were Honorable Mr. Justice A.K. Sikri, former Judge Supreme Court of India, Ms. Pinky Anand, the Additional Solicitor General of India, Mr. Jaideep Gupta, Senior Advocate, Mr. S. Guru Krishna, Senior Advocate, Mr. V.K. Shukla, Senior Advocate, and Mr. Kirti. In today's webinar, our intention is to know the views of some other advocates who are not designated senior advocates, but are very busy and well-known advocates in their respective fields. Because the working of senior advocates and other advocates are quite different, and our today's guests know the pulse of advocacy and day-to-day problems being faced by general and majority of lawyers during this lockdown. In e-filing of petitions, counters, applications, vakalatnama, getting those matters listed, and hearing through video conferencing. Now, it is being demanded by several bar associations and Bar Council of India also to resume physical courts. And recently, Honorable Dr. Justice D.Y. Chandrachud also said that virtual courts cannot substitute physical courts. In this chain, I welcome our guest today. First of all, I welcome our chief guest, Honorable Mr. Justice Sanjeev Sachdeva, Judge, High Court of Delhi. I welcome Justice Sachdeva. I welcome Ms. Tanuja Manjari Patra, Advocate. I welcome Mr. Krishna Kanhaiya Pal, Advocate. I welcome Ms. Pragati Nikhra, Advocate. I welcome Ms. Garima Prashad, Advocate. I welcome Shri Prakash Sinha, Advocate. I welcome Mr. Sanjay Gupta, Advocate. I welcome Mr. Ravi Prakash Mehrotra, Advocate. I welcome you all. Now, to begin with, I invite Mr. Vikas Bansal, the President of the Supreme Court Young Lawyers Forum, to say a few words to start the program. Mr. Bansal, please.
Abhishek. Good evening, everyone. Honorable Mr. Sachdeva, Judge, High Court of Delhi. Our distinguished speakers, Mr. Ravi Prakash Mehrotra, Mr. Sanjay Gupta, Mr. Shri Prakash Sinha, Ms. Garima Prashad, Ms. Pragati Nikhra, Mr. Krishan Kanhaiya Pal, Ms. Tanuja Manjari Patra, the renowned lawyers of Supreme Court, colleagues at the bar, ladies and gentlemen. Today, we are once again assembled at this platform to find out some solutions and suggest the Honorable Chief Justice of India with regard to regular functioning of Supreme Court and other courts. Because resumption of regular courts and physical hearing of the matters is very essential to deliver the justice to everyone, as well as survival of legal fraternity, and also to maintain an effective judicial system. We had conducted a webinar on the same topic on 22nd of May 2020, presided over by the Honorable Justice A.K. Sikri, former Judge, Supreme Court of India, Ms. Pinky Anand, Additional Solicitor General, Mr. Jaideep Gupta, Mr. S. Guru Krishna Kumar, Mr. V.K. Shukla, and Mr. Kirti, senior advocates, also graced the said webinar. All our distinguished guests were of the opinion that resumption of must. Without physical hearing of the matters, justice delivery system cannot be called an effective system. and through virtual court, we could not achieve this goal. COVID-19 has devastated lives all around the world, and we have no option but to practice self-isolation and to maintain social distancing. It is a harsh reality that COVID-19 is not going to be cured soon, and we have to find a way to live with it. We, the humans, the most intelligent creation of God, are capable to survive against any crisis, either in the form of natural calamity or pandemic like COVID-19. Today, the hearing of court matters is being conducted via video conferencing, but to a limited extent, and only few lawyers are benefited from this system. This system is also not feasible as it has technical difficulties also. Past court hearings have proved that the virtual courts cannot be a substitute to regular courts. It is humbly requested by the Honorable Chief Justice of India to kindly consider the request for resumption of regular courts with certain restrictions as prayed by lawyers who are facing great hardship. May I suggest some? Honorable Court may not take more than 40 matters in a day individually by all benches. Honorable Court may sit in 2 or 3 phases daily. Lawyers of first 5 matters should be permitted in courtrooms. Not more than 3 lawyers, and in case of government matters, not more than 5 lawyers should be permitted in courtrooms. Video conferencing must be optional after getting consent of both the parties. I would like to mention that Honorable High Court of Kerala as well as Honorable High Court of Chhattisgarh notified to function with its full seating strength, and the benches will hear the matters through physical seating in court halls with certain restrictions. The Allahabad High Court has also issued guidelines for functioning of district courts in the state during the lockdown. The Bar Council of India also urged the Honorable Chief Justice of India to take note of real difficulties faced by lawyers and resume the normal functioning of the courts. Recently, the Karnataka High Court also notified to start functioning of the courts from 1st June 2020 with certain restrictions. The open court hearing constitutes the spine of our judicial system. Moreover, there are about 2,000 lawyers who are on panel of different states, including Union of India, and there are more than 1,000 junior lawyers who depend upon the day-to-day hearing of the case in Supreme Court alone. I may also request the Supreme Court Bar Association, our parent body, and our association to sit together and find out some ways for functioning of regular court and pursue the Honorable Chief Justice of India to take appropriate decision. At the end, on behalf of myself and Supreme Court Young Law Forum, once again with folded hands, humbly request the Honorable Chief Justice of India to find out the solutions to resume the regular functioning of the Supreme Court with certain restrictions so that the lawyers, especially the junior lawyers, could come out from great hardship and enjoy a better life with their families. Thank you. Namaskar.
Thank you, Mr. Bansal. Thank you, Mr. Bansal. Now I invite Ms. Tanuja Patra, advocate. Ms. Tanuja Patra, please come.
Yes, sir. Thank you, Abhishek Atrisha. Good evening to our esteemed guest, Honorable Justice Sanjeev Sachdeva, sir, Judge High Court of Delhi. Good evening to all our respected panelists, Mr. Ravi Prakash Malhotra, sir, Mr. Sanjay Gupta, sir, Mr. Shri Prakash Sinha, sir, Ms. Garima Prashad, ma'am, Ms. Pragati Nekhra, ma'am, Mr. Krishan Kanhaiya, sir. I'm really thankful to Vikas Bansal, sir, President of Young Lawyers Forum, to giving me this opportunity to express my opinion regarding this topic. Now the whole world is fighting against this pandemic, which is very unexpected, which was very unexpected. In this situation, we don't have any particular idea when this will leave us and when we'll be able to live a peaceful life in a normal manner. So in this situation, we were forced to stay at home in the fear of life. Livelihood took a backseat in that situation. We were now, I can remember from last 2 months, we are sitting idle at home only. We don't have any work. Livelihood has been stopped by a red dot in the fear of COVID-19, but not life and needs. Needs are continuing. Life is going on. We have to survive in this way. For the survival, we need the basic things what we lawyers, young lawyers, earn from our livelihood. We can say this is our profession. So in this situation, as a young lawyer, I can understand the pain of the community, lawyers community, especially the younger lawyers community, who are going through in this situation with lots of pain and miseries. They don't have money to pay their rents for their regular expenses. So it's became a real struggle and need of the time. So in this situation, though Supreme Court is functioning in virtual court hearings, but I can say it's a privileged access or access to limited community, limited persons. So it's not everybody's cup of tea. Everybody is disturbed in this situation. I can suggest that in this situation, when all other high courts, as Karnataka high courts, I would like to quote Vikas Vansal sir in this. Karnataka high court will start functioning, physical functioning, but they by following with all the safety norms, and only 20% are lawyers. In total 20% will be accessed inside the court at a time. So in the same way, Supreme Court and all other courts can also function when all other sectors has started functioning by following safety measures, social distancing, mask, sanitization. In the same way, legal system can sit idle. As we are sitting idle, it's a loss to the community as well as to the litigants. It's a harm to the justice as well. So in this situation, by keeping in this view to the welfare of both the lawyers and the litigants, in this situation, from my point of view, from my opinion, it would be my request to the learned court, Honorable Justice, that this is the time we should also function. The Supreme Court of India should function now by following all the safety measures. We can also follow social distancing and all other guidelines followed by the state. In the same way, it would be a great help to the lawyers as well as to the litigants. So this was my limited opinion. Thank you so much.
Thank you very much, Pal, advocate. He is practicing in Lucknow High Court. Mr. Krishan Pal, please.
Hello everyone. All the panelists and all those who are attending this webinar. First of all, I want to submit that the Awadh Bar Association of Lucknow bench submitted suggestions before the Honorable Chief Justice of Allahabad High Court, and he has approved the certain suggestions which I am submitting before this webinar. First is that no urgency by Monday. Second, there will be no filing. There will be more filing counters. Third, filing timing will be up to 2 p.m. Fourth, the stamp reporting will inform all the defects in online one time on the filing gate, and all the facilities will be provided, and for district's ticket, Bar Association will open the counter. And next suggestion was that the advocates who can't afford the in the premises of the Honorable High Court. And certain other suggestions which were sent by us before, those are: first, only fresh matters filed through e-filing. E-filing should be taken up by the respective honorable courts. Second, all bail matters, including bail matters in pending criminal appeal, should be directed to be listed. And third is, only urgent old matters should be taken up by respective courts upon the urgency application filed by the council parties in person. Fourth was, physical council of the parties side was, cases should be, and same other popular video conferencing software should be used for their purpose, because the performance of Justice Gypsy Meet app is not so good. And other suggestions was, the process of e-filing system must be simplified. This is more important suggestion which was sent by our Bar Association. And next was, no adverse order would be passed against any party in absence of either counsel. And since the use of central air conditioning system is prejudicial in this crisis situation, therefore the same should not be used during this.
Mr. Pal, you are not very much audible.
Will be continued up.
Your connection, your bandwidth is very low.
Mr. Pal, you can switch off your video. I think then we'll be able to hear you. You can switch off your video and shift to audio. We'll be able to hear you very clearly, I think.
Should I call next?
Okay. Is it?
Yeah, now we can hear you. I think you can continue.
Continue.
This arrangement should be continued until 30th June 2020, subject to future that there are various containment zones in which movement of every person, including the lawyers residing there, is strictly prohibited. Hence, video conferencing here must be continued until the COVID-19 pandemic of crisis.
Mr. Pal, your connection is very, very poor.
We'll call the next speaker.
All right. In the meantime, let me see. Thank you, Mr. Pal. Now, in this chain, I would like to invite our next speaker, Ms. Pragati Nikra. Ms. Pragati Nikra, is she here?
Yeah, she's here. Pragati, your mic is on, please.
Yes.
Pragati, please switch on your mic.
It's from your side, it's mute.
Can you hear me?
Yes,
now we can hear you very clearly.
Okay. Honorable Justice Sanjeev Sachdeva, Vikas Bansalji, Dr. Abhishek Atre, Uday Gupta, respected panelists, and all my dear friends. Today, I feel honored to be a part of this webinar as a panelist. I must share with you that when Mr. Vikas Bansal called me up and offered me to speak on the subject in the webinar organized by the forum, I was startled, wondering why me. I think I haven't still attained that stature where I would be invited to share my views, that too with lawyers. But Mr. Bansal made it very clear in the very next sentence, without giving me an opportunity to ask, that we want to give an opportunity to young and regular advocates to speak. Even they should get a forum. Everyone here, seniors, renowned lawyers, and eminent personalities. Thank you, Mr. Bansal, for inviting. To begin with on the subject, I would say we regular lawyers form the bulk and are at the core of the system, be it overcrowding in courts, registry, canteens, dealing with clients, attending functions organized by the court, instructing seniors. We have dealt with all the situations in the past. We are again here to put our system more strongly back to normal. We are here to devise a new normal. This normalcy is not likely to return overnight, and court functioning can be resumed only in a structured manner. Normalcy now would include virtual world along with the physical world. Rule of law is vital to functioning of a democracy. Even at times of pandemic, it is essential courts are able to administer justice. Although COVID-19 has caused a havoc in us in all spheres of our life, but it is teaching us to keep up all our alternatives open and well placed. Running of courts and tribunals is an essential public service. Since the invasion of technology in our lives, for last more than 20 years, half of our lives have shifted to virtual world. Be it television, computer, mobile phones, we have been dependent on it in one form or the other. Now it is time to revamp and upgrade our technology to provide an effective justice delivery system without any technical glitches and complaints. The resultant satisfaction should not be less than physical court hearings in the past. Both virtual courts and physical courts will have to work hand in hand. To reduce overcrowding, paperwork, e-filing has to be made an order of the day. Option can be given to the advocates comfortable with a virtual hearing to opt for it. All chamber and registrar court matters with respect to seeking direction on simple formal application, completion of pleadings can be conducted through virtual court. All clients and interns can be given virtual links to attend court hearings. For all this to function smoothly, we need to train ourselves, our staff and registry officials. In earlier times, we used to carry our own glass and plate everywhere. We can install hands-free coffee, even to have coffee with our friends, keeping in mind our social distance norms even in the canteen. Further, each one of us should pledge to maintain personal hygiene. Since I just want to give you an insight to how UK is dealing with criminal justice system at the moment. The latest guidance from Crown Prosecution Service tells prosecutors in England and Wales to use alternative options to charges, including dropping of cases of less serious offences to alleviate pressure on courts. They have been asked to prioritize the most serious criminal cases during crisis. With less serious crimes, prosecutors are asked to consider out-of-court disposals such as caution or community resolution, as well as stopping cases where the public interest does not require a hearing. This will not affect the most serious cases or violent type of crimes. They should be dealt in strict manner in accordance with law. It has been prioritized. Similarly, we also need to prioritize our cases and deal with them. I totally understand the plight of the lawyers today facing because of COVID-19 who are not being able to attend courts or have been their livelihoods have been hampered. But with COVID-19 not going so fast, we have to live with it, and we have to make this gradual changes from using both the worlds, physical world and the virtual world. It cannot be now. In future, we have to switch to half of our workload has to switch to virtual world. It cannot be just by physical court, because overcrowding is a problem in the court. To say this on the webinar, to say this that yes, we can maintain social distancing, we can have 5 cases in one slot. It is not only the burden is not only going to be on the lawyers, it is also going to be on the judges, who will have to sit through the day, then go back, do their homework of writing judgments or finalizing orders. And similarly for us also, for lawyers, like similarly, we also face this problem when we have these chamber judge matters. We keep waiting the entire day. Like now the court will get up, then the single judge will sit, and then that results in wasting of time. So we have to devise something. We have to take both the worlds, this virtual world and physical world. I know this COVID-19, we were taken unaware of the situation, but now that we have seen like how things will, we are now being prepared for future. So my suggestion would be like, I may not, the organizers may not agree with me, but yes, I feel the change has to be gradual, and both the worlds have to be taken into account to bring back the system in place. Thank you.
Thank you very much, Ms. Negra. And your suggestions are very valuable. Now, I would like to invite our next speaker, Ms. Garima Prashad. Welcome. Please. Yes, Ms. Garima Prashad. Your voice is not audible. You please unmute yourself.
Garima, you have to switch on your mic from there, Garima. You are inaudible.
You have to unmute yourself, Garima.
Yeah, thank you.
Yeah.
Am I audible?
Yeah, you're audible, please.
Good evening, Justice Sanjeev Sachdeva, all the esteemed guests and panelists. A very big thanks to the Young Lawyers Forum to actually grant me this special opportunity to come forward and share some of my views. I don't know how valuable they will be, but I'm much glad that I've been granted this opportunity. So I have been one of those few very fortunate lawyers who I consider myself extremely fortunate. I have been working, I think, each and every day throughout this past 2-3 months, and being for the state and for the authorities. The first and foremost request is that lawyers should be declared as Corona warriors. There is no way that we will be able to go ahead unless we are accepted in the society as Corona warriors. Unless the government accepts that lawyers do the same level of dedicated job to the society as the doctors are doing, or other health workers, or the government or the police is doing. I must say that we are no less. When I have been briefing the Solicitor General, Additional Solicitor General, every day without fail, I have been going to their offices. Come what may, what problems arise, we are ready to fight. We are ready to lay down our lives as much as a nurse or a doctor or a municipal authority officer is doing. They are ready to lay down their lives. Lawyers are no less. We fight everything. We are ready to do everything for our clients. We go to whatever extent possible. We will take care of ourselves. Everything will happen the way normally we do. It is just that the acceptance of lawyers, the dedication and the work that we do has to be accepted at the highest level. We should not be required to say that we are lawyers and people will smite us. We are not going out only to make money. We are there. Money just comes because of the hard work we are doing. But it is the social acceptance of the judicial system also being one important leg of the constitution. Unless this leg of the constitution works, this entire constitutional system will fail. The faith of the public is going. There is a high level of increase in cases of abduction, cases of burglary, domestic violence. Why? Because the message which is going to the society is that courts are not working. Virtual courts, some essential and some very important matters or urgent matters are getting listed. But the overall image which goes to the society at large is courts band hai and we are not working. Our clerks are not coming. People are not working. So courts are not working. We have to change this. We have to bring about a social acceptance of lawyers being a service-oriented organization. All levels of lawyers, even if they are doing small bail applications, even if they are going to the highest of offices for the most important matters. Matters are not less important or more important for a lawyer. If we have 3 matters, all are equal babies for us. We fight for our cause. We fight for getting relief for our clients and justice for our clients. Why should this process not be a corona warrior? Corona has entered all phases of life, but corona warriors have been permitted by the government and they are being saluted everywhere. I would say that lawyers perform such a function in the society which no one else can. No doctor, no health worker, nobody can perform the function that lawyers perform. But we are the most smited and looked down upon profession. We are told that, you are some extra people, you are here just to make your money. Sorry, we are not here to make our money. We are here to serve the society. When clients call us for bail applications, when clients call us for a stay on their home orders, some problem they are facing out there because of which we need to give them relief. My request to Lordship is, and my request to the organizers is, kindly forward the message to declare lawyers as corona warriors. Thank you.
Thank you very much, Garima. Thank you very much. Now, I would like to invite Mr. Shri Prakash Sinha, advocate. Sir. Yes, Mr. Sinha, please. You please unmute your mic.
Am I audible?
Yes, yes, yes. Purely audible.
Good evening, Honorable Mr. Justice Sachdeva and friends, including Vikas Bansal, Dr. Rathre, and all the other persons here. Before I start, I must say, and I remember it, way back it was, I believe, 94 or 95 or 96 in Delhi High Court, when Justice Sikri was a practicing lawyer. He came out of the courtroom, he argued extremely well, and he was heckled by a number of youngsters. I believe they were students, and they were telling him that you did not argue this point. And in normal course, Justice Sikri was a polite person, even as a lawyer. And he said he has to ask those persons, do you understand English? So this was the situation. So the idea before open court is that it should be in the public gaze. The public must understand that what is going on in the courtroom. So the problem that was faced by Justice Sikri as a lawyer, he was senior counsel at that point of time, if I remember it correctly. So it is the problem of the people's perception. So that is the reason open court is necessary. It has to, it has the people's confidence. They must know what is happening in the court of law. Now the next stage is that this COVID-19 came, and as a result, there is a lockdown. It is but natural because it's a worldwide phenomenon. My simple point is that so far the medical science is concerned, it is an approximate science. So far this virus is concerned, it is changing its nature every other day. As far as we know, as on date, if you are maintaining social distance, if you have got good immunity, then obviously, even if it touches us, it will not affect at least 80% of the population. So we stay there. It may touch us, it may not touch us, but even if it touches us, it is not going to affect us. So in this background, if there is a lockdown, then ultimately we have to work in this virtual scenario as well as the courts have to be open, because there can't be any substitute of open court hearing. Virtual court hearing can be a stopgap arrangement. But so far these things are concerned, I am looking at that this may continue till December or January or maybe till March next year. So what happens next? If you take the example of Supreme Court, we have to follow this virtual hearing. So far the cases before registrar is concerned fair enough, because the idea is that there has to be some social distance. This overcrowding has to be stopped. So the courts, the registrar courts, it can conduct all the proceedings through virtual hearing. There is no denying the fact. So far, the other courts are concerned, assuming for a moment, roughly there are 12 courts in the Supreme Court in general. Then first 6 courts, in whatever manner, they can sit in the first half. Instead of 10:30 to 1 o'clock, it can be 10 to 12:30. The next 6 courts can sit from 2 to 4:30 or 4 o'clock. This is 4:30, 4 hours, 30 minutes is the usual time of the court timing. In this manner, we can at least maintain social distancing, and we can control this crowding, overcrowding. You go only to the first 6 courts, and once again in 6 courts, there has to be a limited number of matters. We must understand, but this may continue till December. So in this manner, we can have the virtual hearing, and at the same time, we can have this regular court functioning also. Apart from it, obviously, we have to maintain social distance, A, the immunity, B, C, the hygiene, like a mask and sanitizer, etc., etc., etc. So in this manner, we can, at least these regular courts can function. So for filing is concerned, obviously there can be an e-filing. There is an e-filing, no doubt of it, and we can go ahead with this e-filing. There can be one hard copy also for the judges, at least in the Supreme Court, because I remember I appeared in that infamous Bombay bomb blast cases. The documents was running into 1.5 lakhs pages. They have got all these things in a CD, and they said that you have to argue on the and you have to peruse the records from the computer. It was difficult for the judges as well. It was difficult for the lawyers as well. But gradually we learned the things. Still, at that point of time, I requested the honorable judges that have a hard copy of it, because throughout the years we are used to look into the files. We are thumbing through the files. We can't work on a computer like that. It was difficult for the lawyers, so it was difficult for the judges also. But gradually we improved upon. Now in a number of cases, there is a video conferencing. So far Supreme Court is concerned, no doubt of it, we can have both video conferencing as well as the regular courts. Regular courts can be scattered. The number of cases can be limited. Social distancing can be maintained. Even before the lockdown, 4 or 5, the lawyers of 5 items or 3 items, they were allowed to go inside the courtroom. So in this manner, it can be managed. So far, this is Supreme concern. So far, High Court is concerned. Once again, there are 3 buildings. And 3 buildings, the hearing can be separated in all these 3 buildings in alternate days, along with the virtual hearing. So for trial court is concerned, yes, it looks a difficult proposition in the sense that it can be done in the Ross Avenue Court, but it will perhaps be difficult in Saket and Dwarka courts, because ultimately people have to take the lifts because of the structure of the courtroom. So this is the scenario. So my humble request will be ultimately that you can open the court in a graded manner, in a structured manner, have 2 sittings of first 6 courts in whatever manner it has to be kept in the first half, and the next 6 courts in the second half. In this manner, at least overcrowding can be reduced. Okay, thank you very much.
Thank you very much, Mr. Sinha, for your valuable suggestions. Now I invite Mr. Sanjay Gupta, advocate. Gupta sir, please.
Good evening, Honorable Mr. Justice Sanjeev Sachdeva, Mr. Vikas Bansal, Mr. Uday Gupta, Dr. Abhishek Atre, my dear friends. So today's topic on the resumption of regular courts is very pertinent, not only from the point of view of the access to justice, but also from the perspective of the legal profession. Now, COVID-19 has instilled the fear of unknown in everyone, and it's going to stay for next 10 to 12 months. And it has impacted everyone. Every individual, every institution has been impacted. Some are severely impacted and some are moderately impacted. But so far as the judiciary is concerned, I would say that judiciary has been severely impacted. It has been impacted because it has resulted in the delay in the disposal of the cases and has also impacted the practice of the lawyers. Now, although the courts, they have taken some laudable steps, by conducting virtual hearing, video conferencing. But considering the technological divide between the haves and have-nots, I think it's a distant dream. And moreover, the technology can't work in vacuum. So there has to be a proper infrastructure. The infrastructure in terms of financing, in terms of bandwidth, in terms of platform, in terms of uninterrupted power supply, and more particularly in terms of the change of the mindset of all the stakeholders. So whether it's a litigant, whether they are judges, or whether they are the lawyers. So I'm not saying that online courts can't happen. It can happen, but it's a project for future. So now, considering that we have 20 lakh lawyers in India practicing in more than 600 district courts and 25 high courts and Supreme Court, and there are also lawyers who are practicing in commissions and tribunals, and there are over 3 crore cases which are pending in different courts. Now, this COVID-19 has actually increased the longevity of all these cases. Now, to say that legal profession is an essential service, I would say it's like demeaning the judiciary. The judiciary is the pillar of a democracy, and it, according to me, it cannot come to a halt. And the debate which is going on, that there has to be a resumption of the regular courts, according to me, there can't be any debate. The courts must necessarily resume the work. And why? See, there is going to be a problem. There's a fear of spread of coronavirus, but we have to deal with it. So it can't be that while sitting at home and we'll just think that this virus will vanish. I have few suggestions, and I think it may be considered. So far as the High Court is concerned, I would say that there should be a categorization of cases to start with. Now, categorization of cases, say original site where the pleadings are complete, statement of witnesses have already been recorded, and they are ripe for final hearing. The appeals, there is no requirement of filing any additional pleadings, and even in Section 34 petitions and the Arbitration Act, there is no requirement of filing any additional pleadings. So these cases where the presence of the client or the interface with the public is negligible or minimal can be heard instantly. Number two, according to me, the courts should think of working in shifts. They can have morning shift, they can have afternoon shifts, rather than putting the entire burden on the functioning of the courts. So it can be split into 2 shifts. And also the e-passes should be issued to lawyers, to only those lawyers whose cases are listed before the court. And they should be allowed to enter the courtroom according as per the list in batches. Also, I think the important role is of the bar associations. Bar associations, although they have financially helped many lawyers, but according to me, in one aspect, all associations have failed. The bar associations at national and at all district levels should sensitize the members. They should sensitize the members about the social distancing, about the safe work practices, about the new normal in view of this pandemic situation. So the big role has to be played by the bar association. They should propagate. They should hold webinars. They should have these Zoom meetings. They should tell their members that this is the situation which we are facing. I hear all the webinars on all the topics, but I have never seen any webinar by any association inviting the members that you please, what you have to do. Secondly, then obviously, I mean, everyone has said that, there should be hand sanitizers and also masks, gloves. These are there. Then I would suggest that the court should also start having at least 10 to 15 cases. Normally in Delhi High Court, what I have seen that there are about 1200 cases which are listed every day. The 30 to 40 cases, they are being heard by each court. So to start with, we can have 10 to 15 cases, or maybe we can start on alternate days. So we have to come out with some kind of solution. And also I would suggest that high courts, being the can exercise the power of superintendence, should also ask for SOPs from the tribunals and commissions, because the lot of justice dispensation system has been transferred to these commissions and tribunals. So they should be asking for the SOPs from these commissions and tribunals. And I would say that although I'm a big proponent, I'm a strong believer of the open court system, but the way the things are going on, online courts and online judging is going to be the future. Litigation will be transformed by technology, and according to me, it is no more res integra that in future we'll have online courts, but the question would be how they would become a norm. So I'm hopeful that the courts, bar association, and all these stakeholders would think seriously and would come out with some kind of solution to this problem. Thank you.
Very much, Gupta sir. One thing Mr. Gupta highlighted, that we are such a large number of advocates in India, about 6 lakh. It should be essential services. In our last webinar, Ms. Pinky Anand, when she was giving her address, she mentioned that in several countries, advocacy comes in essential services. It is only in India, this is not an essential service. Thank you, Mr. Gupta. Now, in this chain, I would like to invite Mr. Ravi Prakash Mehrotra, sir, our next guest. Please welcome.
Justice Sachdeva, my friend with whom I spent 3 memorable years in the Campus Law Center, my fellow panelists, and all those who've tuned in, my greetings. Trust you're well and taking care in these rather unprecedented and exceptional circumstances in these unexpected times. The world order is changing, as are societal and individual perceptions in all spheres of human activity. And so it must, in order that we keep pace holistically with this new normal in thought, deed, and action. Countries across the world are grappling not only with fighting the disease, but also modeling new systems and methods around this pandemic. COVID-19 has shown the adaptive nature of human beings and highlighted the imminent need for institutions to be equally prompt in their response. Justice delivery systems the world over have put their faculties together to ensure that the wheels of justice keep running by adapting and using technologies. In India, the Supreme Court has issued directives authorizing the courts to adopt measures required to ensure the robust functioning of the judicial system through the use of video conferencing technologies. Friends, the subject today is very relevant to the situation that confronts us. Will regular or physical courts be resumed? The challenges in this regard and the way forward. In my view, any switch to the virtual court system is obviously not without challenges. While virtual courts today are currently out of necessity and are a welcome arrangement, whether stopgap or otherwise, they raise both significant procedural as well as access challenges. Concerns of efficiency, privacy, fairness, security, accessibility, transparency, coordination between agencies, it needs to be seriously considered. The question is also whether the need, requirement, and the role of various stakeholders in the legal system, being the citizenry, judges, lawyers, court staff, police, forensic laboratories, the prisons, the prosecutors, government lawyers, investigating agencies, government departments, and different ADR fora would be able to easily and seamlessly adapt to the virtual system. Courts on the original side, in my view, would face difficulty since aspects of evidence, appreciation, cross-examination, and such have to be considered. Aspects relating to personal interaction, body language, etc., assume importance in this scenario, for which physical court proceedings become important. As one goes down the hierarchy of courts, the number of cases and their complexities also increase. Physical presence in a court of law serves an important expressive function, which cannot be completely substituted by virtual hearings. There are also issues relating to accessibility and connectivity to courts in a virtual world, given the extent of internet outreach in our country, which currently stands at around 50%, though growing, but is far from ensuring a level playing field. The socioeconomic condition of lawyers and litigants and their consequent limited access to technology and technological skills are not consistent with a complete shift to virtual courts. In this scenario, the big question and the loaded question is, which is the way ahead, which is the way forward? In my view, the way forward ought necessarily to adopt a two-pronged approach, where while strengthening the virtual court infrastructure, which is inevitable and unavoidable in the present scenario, and which is likely to continue for quite some time, mechanisms and strategies be developed to facilitate open court hearings as well. In my view, a pilot project with, say, half the strength of courts conduct open court proceedings with appropriate cases, or where lawyers or parties in person so indicate at the time they file their case that they would rather have a virtual or an open court hearing. It is important that we develop a hybrid system that can address the concern of all stakeholders in the legal system holistically, taking into account the sensitivities of the cases at hand. A few suggestions for running of both physical courts as also bolstering virtual courts may be as follows. Physical court proceedings, to the extent possible, be conducted as aforestated in addition to virtual courts. Thereby, the transition would be smooth and the virtues of virtual courts be easily understood. A pass system could be evolved where time slots be given for entry to court premises based on court hearings. Appropriate waiting areas be created with adequate safeguards. Documents in e-format can be exchanged between lawyers, parties, and judges, even in the case of open court hearings, to ensure minimal contact and physical presence. Training is imperative and essential for judges and lawyers alike, which should be conducted on a large scale to familiarize them with navigating virtual courts. Ample number of accessibility lounges be made available in or around the court precincts for lawyers and litigants to attend virtual hearings who may otherwise find it difficult. And lastly, the current virtual court setup, we all understand that the judicial system has evolved ways and means and methods to combat and to deal with the present scenario. But in my view, there should be a legislative framework with ample enabling and safeguard provisions. These are some of the thoughts which I thought I would share with you. And on this very important issue, which has been flagged by the Supreme Court Young Lawyers Forum, I very heartily congratulate the organizers and thank them for giving me the opportunity. Thank you very much.
Thank you very much, Mr. Mehrotra. Now it's time to hear our chief guest, Honorable Mr. Justice Sanjeev Sachdeva. Justice Sachdeva, sir, please.
Thank you very much. And I'm very happy that the organizers have organized this webinar on a very important topic, which is very close to the hearts of all the lawyers and, let me tell you, all the judges as well. One misconception that I have observed from the speakers prior to me, there is no debate that virtual courts are going to replace regular courts. That is nobody's wish, that is nobody's intention. So the mindset that virtual courts are a substitute for regular courts, well, nobody's even contemplating that. We are far, far away from that situation and nobody wants it. But problem is that today, because of COVID-19, virtual courts actually became the lifeline. Some of the countries across the world have closed down the legal system completely because they could not go virtual, courts could not function. So in India, especially all our courts, beginning from the Supreme Court, percolating down to the district courts, the lifeline was the virtual courts. Yes, as the speakers prior to me and Mr. Malhotra said, it is a new normal. Nobody expected it. Nobody thought it'll happen. We all were taken by surprise, including the legal system. Luckily, in India, we were progressing towards digitization to a great extent. So it was easy for us to transit and create that lifeline, which was very much needed in this hard time. Now, before I will answer each one of the speakers and the points raised by each one of the speakers, but before that, I would like to share a PowerPoint presentation on resumption of courts. Now, this is what is causing a major problem, coronavirus. And what is the solution? Practice social distancing. What does this mean? Avoid non-essential travel. Maintain social distancing. Now, let me give you a glimpse of what our regular courts were. Now, this is the photograph of the Supreme Court. We all are familiar with the Supreme Court. And let me tell you, I was an advocate on record for 20 years. And I'm aware of the difficulties that an advocate on record faces, young lawyers who are facing this. Now, look at the condition. This was the normal. We are all aware of the Monday and Friday situation in the Supreme Court. These are some of the glimpses of the Supreme Court. We are talking of social distancing. This is the Delhi High Court. These are some of the district courts. In the kind of atmosphere that we had, this was the normal in the district court complexes. And what are the challenges in opening the regular courts at present? Well, a video was circulated on the social media, and we saw, some of us must have seen this.
ये 29 नंबर कोर्ट है। यहाँ पे वकीलों की सोशल डिस्टेंसिंग नहीं हो पा रही है और अधिकारी और ये सबके लिए है। यहाँ पुलिस अधिकारी भी खड़े हुए हैं। ये देखिए सब एक साथ चिपके हुए हैं। जगह नाम की बिल्कुल चीज नहीं है यहाँ पे। और पदाधिकारी बोलते थे कि कोरोना आएगा, इसलिए उन्होंने काम रुकवा दिया था। और जो वीडियो बनाया है वो भी बाहर के अध्यक्ष और
This is what happens if you open the court in the present situation. Well, that was a very unfortunate incident. So what is the remedy? Please change your mindset. Transform the court from this to something like this. This is the scene of a courtroom, which we've seen very often. In this kind of a situation, in the present time, can you maintain social distancing? Well, you can, but with use of some technology. One of the speakers before me mentioned that, Mr. Sinha, that the statistics shows that this is not going to affect probably 80% of the population. Have you imagined what is that 20% which will be affected? In a population of 137 crore, we're talking of about 27 crore people. That's the number of 20%. Can we take that kind of a risk? So we have to look at maybe a paperless court. We can have a e-system for advocates. This is a real-time photograph of a complete paperless court. Now, you see, as advocates, the issue that arises is it's very easy to talk of paperless court, e-courts. But as an advocate, what is the software, what is the application I need You see, the problem today is not technology. Problem is being aware of the technology. Mr. Gupta, before me, mentioned about the role of bar associations and them holding webinars. My suggestion to the bar associations is that please hold webinars, hold training sessions in empowering young lawyers, not only young lawyers, empowering all advocates in digitization. Because we are not going to go back to the normal which existed before the corona outbreak, at least not so soon. So there has to be a new normal. And we all will be able to face those challenges if we are empowered, if we are trained. It is high time the bar associations took up the responsibility of training advocates in how to digitize record, how to file documents, how to use virtual courts, or maybe develop a hybrid system. But saying that completely close down one system, come back to the other, whether it's from regular courts to virtual courts or vice versa, that would not be the solution. And let me tell you, for a virtual court, for an e-system, you don't need too much of a software. All you need is a PDF reader. Several free softwares are available that permit annotation, underlining, bookmarking. Then you need Microsoft Office. We all use Microsoft Office. We all use PDF readers to read PDF documents, to create a document. Now, a digital court file is stored in PDF format. Now, we all wonder that, look, we type documents in Word. How are we going to convert it into PDF format? It's going to be very difficult. Well, files are also maintained in portfolios. I'll be showing a couple of portfolios later on. Now, it's very easy to create a PDF file, and especially in Supreme Court, where every page has to be typed. You can create a PDF file from a Word document while it is being typed. You can create a PDF document by scanning a document. Well, if facility is not available with individual lawyers, Bar Association can create lounges, which was just mentioned, that there should be some accessibility lounges. Well, bar associations can create space. The courts are endeavoring to create space which will facilitate lawyers and litigants in creating PDF documents. Now, for example, in a Word document, when a Word document is typed, all you need to do is go to File, in a Word 2007, save as an Adobe PDF, and a PDF document is created. That's all. Nothing more is required. In a 2010, 2013, you create a PDF document and a document is created. In case of unavailability in the software that you have, then Microsoft permits free download of PDF XPS converter documents. In a MacBook, Apple machine, you can simply export to PDF. Simply go to Save As and save as a PDF document. Likewise, or you go to Print as a Microsoft Print to PDF, and a PDF is created. There is also OpenOffice available, which is an open source word processor, which is fully compatible with Word. Install it on your computer, download it, export to PDF, and a PDF is created. So it's that easy. Alternatively, you can go to a free PDF conversion website and convert a Word document into PDF. It doesn't cost anything and takes a few seconds. In Supreme Court, where everything is typed, it's very easy. There's no difficulty at all. Simply convert it to Word, file it in PDF, file it, and digitally sign it. Most of us have digital signatures. They're all available. It's not very difficult to obtain a digital signature today. Scanning, if you have a scanner, all scanners today, especially the all-in-one printers that are available in the market, provide you with a software whereby you can scan a document and save it as a PDF document. If you have a photograph, you want to scan it, store it as a PDF document, no difficulty at all. For example, Delhi High Court has provided an in-house facility for scanning of documents. You can take your paper file, pay the specified charges, and in fact, the charges are less than a photocopy of a page. He'll give it to you on a pen drive, he'll scan the file, give it in the required PDF format. And in fact, during this period, scanning facility is being provided at the designated e-filing counters in the district courts. E-filing counters have been set up in Delhi High Court, District Court, all the District Court complexes. And like I said, they're all free of cost for the moment. Otherwise, the cost of scanning per page is less than a photocopy charge. Then Supreme Court has already launched the e-filing software. High Court is in the Delhi High Court. Work is in progress, and very soon it is going to be launched, where you can file from the convenience of your office. You don't need to travel to the court, just file the document and that's it. Now, for security purposes, how do you file a case? Question is, how do you file a digital document? For security purposes, you need to register. To register, you need your Bar Council enrollment number. Parties in person can also register. Law firms can register. You need, for authentication purposes, you need to provide your mobile number and email address, because there's several transactions will happen over email. Now, there are practice directions. Mr. Mehrotra talked about legislation in place. Well, Supreme Court is in the present moment considering formulating legislation for the country. Some practice directions have already been issued. Delhi High Court has also issued practice directions for filing and listing of cases. E-filing template. Now, Delhi High Court has provided an Excel sheet template of memo of parties. Sometimes what happens, and especially in Supreme Court, the memo of parties runs into several pages because there are several parties. Now, if you were to physically sit down in front of a computer and type the memo of parties while you're filing, it'll take substantial time. So Delhi High Court provides an Excel sheet template which is filled up when you're preparing the draft of the petition. When the memo of parties is typed, it is typed in the Excel sheet. And the moment you go on to file, the Excel sheet is extracted and the memo of parties is picked up from there. Then you enter the 16-digit code for the court fees and upload the digital file. Now, this is what a court fees looks like. Now, this is the 16-digit code for the court fees. And it can be purchased online from the site of the stockholding corporation. Now, this is a small video of an actual e-filing taking place. A person has come for a main case filing. He's looking for that template of that memo of parties. So this is the template in Excel sheet. He clicks on it, uploads it, and the entire memo of parties is copied. Next, he goes, selects the case type, the case category, then uploads the 16-digit code for the court fees. Then uploads the digital file and the case is filed. It's that easy and only takes this much time. Now, portfolio of a digital court file looks like this. Now, we have separate folders. In a normal file, we will have a separate folder for order sheet, separate folder for pleading, separate folder for application. So a portfolio is converted into these separate folders. Now, this is a portfolio of a suit record, which will also have the portfolio for a document. Once opened, this is what the cause list looks like. Now, on the left, you'll see the cause list. On the right, you see an open portfolio. This is what happens when you open it on a screen. Now, once opened, the portfolio looks like this. And at the one side, you will find that the entire file is bookmarked. So it's already bookmarked. And you can just, by the click of a button, jump straight to that particular bookmark. So you don't have to browse through pages. Even if we go back into regular court, my suggestion will be take a laptop, take a digital file, you'll become much faster while addressing arguments. You can simultaneously take notes. This is a OneNote Microsoft feature where you can take notes by hand and you can highlight, you can underline, you can make a note on the file, because the question which arises is, look, can I highlight a digital file? Now, some people are of the view that no, you cannot, but you can use a digital file exactly like a paper file. And you can also make your comments. By clicking on the comment, you straight away jump to that page. For example, if you're studying a petition and you want to bring the court straight to a particular point and you've noted it, simply click on that comment list and you will jump to the highlighted portion of that page. You can copy it to OneNote, you can copy text. If, for example, you want to type and extract a particular document or a portion of a document, all you need to do is copy paste and it gets pasted, and your steno doesn't even need to then type it. You can simultaneously open 2 pages for comparison. Now this was the, well, say, slightly hybrid system we had before the coronavirus. This was a telepresence hearing which we had in court. This was about a year ago. And this is what the telepresence hearing is taking place these days. Now, if you see, anyways, I'll come to, and benefit of telepresence hearing is like I am right now sharing a PowerPoint presentation. You can share documents during arguments. Way forward, why don't you consider, well, this is something which the court is also considering, give a 10-15 minute audio video electronic submission in addition to your written submissions. Just record a video of 10 minutes of your arguments, request the court, upload the video so the judge looks at that video, hears your argument before you actually come into court. Because if we are looking at a hybrid system of cutting time, upload this electronic video, share it with the other side, both parties exchange their videos. When you come into court, then your hearing is restricted to whatever time slot is allotted. Now we have to reduce footfall. One issue was an open court hearing. We can have live streaming of court proceedings. Again, that's a decision which the Supreme Court and the respective high courts will have to take, whether live streaming should be permitted or not of the court hearing. But in a digital court, on an electronic court, in the present situation, live streaming is possible and it can happen. Now, coming back to the respective points which were raised by all the speakers, like I stated at the beginning, virtual court is not a substitute. And I showed you that in the present situation, social distancing may not be possible. It's very easy to say, let's have, say, courts in shifts. Let lawyers of one shift come in at one point of time, lawyers of another shift come in at another point of time. You see a junior lawyer or a lawyer, well, not only a junior lawyer, lawyers of some standing also don't have a choice. Can you today say that I, as a lawyer, am only practicing in one field? That I'm only a civil lawyer, I will not take up a criminal matter, or I will not take a matrimonial matter or an MSCT matter. If the court were to say, all right, we'll have only MSCT matters in the morning and say 138 matters in the afternoon. Can a lawyer say that I will only come in the MSCT matters and not in the 138 cases? So it's very easy to say, let's hold it in shifts. Yes, at the outset, you see the underlining factor is nobody is saying substitute regular courts with digital courts. We are not saying so, nobody wants it. But in the present situation, question is, can we open the courts and expose lawyers, litigants, judges to a risk? Imagine a situation if it's happened in one of the court buildings, not a court building, but a quasi-tribunal building, where a corona positive person was detected and the building had to be shut down. Imagine a situation where, God forbid, something were to happen in the court premises and the administration were to say, because of that, now we'll have to shut down the court. The entire building comes to a standstill. So we can't rush into it. I have always said that please empower yourself. I've been holding e-courts. Delhi High Court for the moment, all the benches are sitting. All benches hold court every day. And we are listing matters up to 17, 20 matters before each judge every day. 25 benches are sitting. And if some of you don't know, then on the High Court link, there is that display board link. That display board functions for the digital courts as well. We are also contemplating, rather all courts are in fact contemplating providing digital files to the lawyers. So we said 20%, well, instead of say 40 cases a day, we are having about 15 to 20 cases a day per court, per judge. So that is the kind of lifeline we are providing. Now, I have seen in these proceedings which are happening that young lawyers are assisting senior advocates. Now, this is the Young Lawyers Association. I'm very happy that I'm addressing young lawyers because all the young lawyers are very empowered. all of you know how to operate a digital system. All of us do these video chats now, especially that TikTok video which has come now. Everybody makes a video. We all know how to use technology. In fact, you people have to train seniors. Look, we will help you. But another fallout that we've observed is civil litigation has gone down. So the fact that matters are not coming is because today nobody is safe. Everybody is feeling that, look, should I litigate? There is a rethink. Maybe this is the time when lawyers should rethink, advise their clients to have a relook at all their litigation, which is already pending, and see whether it is worth pursuing. Should we have a rethink? Should we settle? Maybe explore the possibility of a settlement with the opposite side. Initiate a dialogue. Speak to the other side lawyer. Let's sit down on the table and let's finish litigation. Because ultimately, you see, the role of a lawyer is not only to appear in court. His role is to get quick and effective justice for his client. So as lawyers, my another suggestion is, please revisit the matters which are pending before you, which are with you. Speak to your clients, speak to the other side, see if you can negotiate a settlement. Maybe work will increase. Once the courts open, court's burden will be less, and we'll be able to dispense quicker and better justice. Again, a hybrid system has to be worked out. At the moment, let's not push. Courts, let me tell you, all courts are working towards opening regular courts. Work is on. We need infrastructure, we need equipment to ensure social distancing. Ways and means are being thought. It's not that judges are doing nothing or the administration is doing nothing. Every day we have meetings, every day we have visits to the court premises to understand how can we resume regular practice. And that has to resume. But now, as said earlier, with a new normal, with a more hybrid system. I think I've taken substantial time. I will, if the organizers have some time, maybe we can take some questions or any suggestions if somebody has. Over to you, Mr. Atre. Thank you very much.
Thank you very much, Justice Sachdeva. Only one word I can say, simply mind-blowing and eye-opening presentation. And the questions will be taken by Mr. Uday Gupta. For that, I will invite Mr. Uday Gupta for vote of thanks and to take questions, if any.
Thank you, Dr. Atre. Honorable Mr. Justice Sanjeev Sachdeva, Shri Ravi Prakash Malhotra, one of my dear friends, Mr. Sanjay Gupta, Shri Prakash Mehta, Ms. Garima Prashad, Ms. Pragati Mishra, Mr. Krishan Kanaya Pal from Lucknow, and Ms. Tanuja Patra. I'll first propose the vote of thanks, and in the meantime, if I find some questions in the chat, I'll put them to my Lord Justice Sanjeev Sachdeva and to the other panelists as well. The first issue why we have organized the second webinar on the same topic is because as young lawyers or as first generation lawyers, we were finding that all our counterparts sailing in the same boat were having great difficulties in using the e-platforms, which have been provided, of course, by the Supreme Court and the High Court and other places as well. The other issue that kept coming before us was that there is no indicia available to judge the amount of damage that COVID-19 has done to the legal system as a whole. The damage is in terms of not how we are going to deal with urgent matters, but the damages to the system as a whole because of the old matters that are already pending before the courts, and the fact that those old matters are not available in soft formats, soft copy formats, either for the honorable judges all over the country or for the lawyers as a community. Now, the present day filing structure, of course, dealing with urgent matters, we can all do virtual filing. There is no problem. I think all of us young members of the bar are learning it very quickly. The senior ones also, in fact, we saw Mr. P.P. Malhotra arguing the other day on the online platform before Delhi High Court, and he was complimented by some of the judges as well, being a very senior member. But the ultimate problem that is arising is that how do we get the old cases back to track? Those old regular appeals which are pending either before the Supreme Court or the regular cases that are pending before the High Court. So that is one issue which I like Justice Sachdeva to also elaborate as part of his answers to a few questions which we'll take up. The other key aspect which I took away from Justice Sachdeva's speech is that fortunately virtual courts are not replacing regular courts for all of us, and that is nobody's idea. So at least that part is very clear, that virtual courts are here for the time being to deal with the COVID-19 situation. Maybe in future, of course, we will find more of virtual courts, less of physical courts. But then at least for the time being, I think we'll have to continue with virtual courts. The presentation of Justice Sanjeev Sachdeva, I think, was wonderful. It is one of the most impressive presentations we have come across in any of the webinars on similar topics. In fact, one of the slides, if we carefully saw, has that scene from that movie Court, which is that Marathi movie which won the prize in the Venice Film Festival as well. It's a very popular movie. If you've not seen it, you must see it. It deals with how, you know, a manual worker commits suicide on reading somebody's poem, the accused poem, in fact, if I remember correctly. So that is one aspect. I thank Mr. Ravi Prakash Malhotra for his suggestions of Mr. Sanjay Gupta, and of all my other friends, Shri Prakash Sena, Garima, Pragati, Mr. Kanaiya Pal. Of course, we missed part of his speech due to some technological difficulties, and that is part of one of the glitches which we find in video conferencing, and of Tanuja, the young on the panel today. May I request that if Justice Sachdeva could just throw some light on how the system is going to gear up with the old cases. The present set of urgent hearings, of course, will continue, and we'll all support the urgent hearings. But how does the system gear up to deal with the old cases before the Supreme Court as also the Delhi High Court?
Mr. Gupta, on 26th April, Delhi High Court had issued a circular that all pending cases which are ripe for hearing in certain categories can be taken up for hearing with consent of parties. Because why we'd mentioned consent of parties was you can't force one party, because that was the time when there was a complete lockdown. We've realized that not many cases have come forward with the consent of parties. And those cases are the category of matrimonial disputes, maintenance, criminal appeals, Section 34 petition, Section 9 petition in arbitration. Now, maybe the next stage, again, that's a decision which the court has to take individually. I can't comment upon it. But seeing the response that we received and the fact that in Delhi High Court, all judges are sitting as per their allocated roster. So there is a possibility, well, if anybody wants his matter to be listed, move an early hearing application. If the court considers matter is complete, direction can be issued and it can be taken up. In fact, some of the judges, let me tell you, in one of the cases yesterday we were discussing, a bail application came up before a court. And it is the regular court which hears criminal matters. And the judge said, forget about bail, argue your main appeal. And the appeal was heard and disposed of. So you see, we all also, even the judges, we've been working, well, you from the legal fraternity know that the judges work 7 days a week. And so do the lawyers, morning till evening. So remaining idle is not somebody's choice. We are also wanting matters to come. Try it out. Maybe your matters will be listed, and maybe the next stage with the court is going to do is open up the regular hearings. But in the present situation, because you see online hearing with the present technology that we have and the glitches that are being faced at the end of the lawyers, is that connectivity gets to be an issue.
Yes.
From the court's perspective, we have the best systems in place. We don't face a problem, but ultimately it can't be a one-way system. So unless the lawyer also hears and is heard, that system doesn't work. So till the time lawyers are able to get appropriate systems, and let me tell you one thing, if somebody is having a difficulty connecting from his, say, desktop, use your mobile phone's 4G as a hotspot. So the youngsters know, they use it very often, they share the hotspot. So please use that, connect your laptop with it. I've tried it, it works substantially well. Better than sometimes the Wi-Fi dial-up systems. It sometimes works better than the broadband. 4G connection, 4G system, some of them give you 60, 40, 50, 60 Mbps, whereas the broadband is only giving you 2 or 3 Mbps.
Yes, yes.
And to connect to court, you need basically only about 2 Mbps connection. But if anybody is having a problem, switch over to your 4G phone, use that as a hotspot and connect. So, and let me tell you, Mr. Gupta, the difficulty was in this period of lockdown, neither the hardware nor the equipment was available. If we said, all right, we want a LAN system installed at somebody's residence, it was not possible. So those difficulties we all are facing, young lawyers are facing, but it's a challenge you young lawyers have to take up. You have to train yourself, push the bar associations to conduct seminars. Well, I'm willing to come and join you and all. If you want, anybody wants to know how an e-court actually functions, how you want to facilitate, make it easier, organize a webinar, I'll be happy to come back again.
I think we'll
may I say something?
Just 1 minute, Vikas. I think Justice Sachdeva's presentation today is almost like what Justice Chandrachud had done on 15th May when he inaugurated the e-court module. And we found a lot of similarities between how we can file it before the Supreme Court and also here. So both were wonderful presentations then on 15th May and today as well. Yes, Vikas, you were saying something.
Sir, sorry to say, but
Again,
always know the technical. We all are very much familiar with the techniques. In Supreme Court, registry is given only links for only 2 advocates. I am a panel advocate in Supreme Court on behalf of Supreme Court of India, Union of India. Central agency marked 4 to 5% in lawyers in a matter. Registry is giving only 2 links to at 1 AOR. How can a panel lawyer get be benefited? We are not getting the matters, not getting the proper links by the registry. The link is not sufficient. That sometimes lawyers are not listening to the court and court are not listening to the lawyers. Where we survive, sir?
Mr. Bansal,
sir,
to your question, the proper answer can be given by the registry. But the only thing which comes to my mind is that, look, everybody was taken by surprise. We had to shut down courts at the notice of a couple of days. It wasn't that we had 3 months, 4 months to prepare. And in this time of lockdown, the courts have been trying to acquire systems, acquire technology, and provide the same to the lawyers. So this is not there to stay. You're right. Merely 2 links per advocate may not be sufficient. You may have a briefing counsel. You may have a senior counsel. So you might need more than 2 links. But then these are systems which are coming into place where all courts, lawyers, judges, everybody is grappling with it. But yes, time will come when it will be a much easier, much easy to use system. So for the time being, I think we all will have to bear with the system and make do with whatever best that is being made available.
Sir, you are right. But how a could survive, sir? Sir, better may I suggest one thing, sir? After COVID-19 is not completed, shut the court, sir. Only some few lawyers are benefited. We are the general lawyer. We are the first generation lawyer. We are sitting at home. Some lawyers are getting the benefit of virtual courts. Why should we not? We are helpless. We are not getting the proper links, and we are at home. And there are only few lawyers who are getting the benefits. Better to close the court all over for 3 months, 4 months, whatever it is, so that we would be happy. Yeah, court is closed, so there is no word. Don't worry about it, sir.
Before Justice Sachdeva answers, I think because
I can't answer that.
You are too emotional. I know. I understand everyone feeling on the panel. I don't want to embarrass Justice Sachdeva by that.
No. In any case, this is not addressed.
It's not something I think in his domain as well. Right now, I think both the sides are trying their level best as lawyers and as judges, and as entire machinery is working to its optimum level to arrive at some kind of a solution. Now, obviously, the solution cannot be the best for each one of us, but then so long cases are taken up, we can't shut courts for 3 months altogether and not deal with any matter that is there on board. So, on that note, my lord, I thank Justice Sachdeva once again for taking time out of his busy schedule and participating in this webinar, and to all my other friends, Mr. Ravi Mehrotra, Mr. Sanjay Gupta, Mr. Sinha, Ms. Garima Prashad, Ms. Pragati Nikra, Mr. Krishan Pal, and Mr. Nuja Patra. Thank you once again for joining all of us and sharing your valuable suggestions. Thank you.
Thank you very much.
Thank you.
Thank you very much, all of you.
Close the meeting. Huh?
Unmute करो सबको.
Close the function.
Close.
End up. कोई बात नहीं.